Paragraph 15, 16, and 17 deals with issues surrounding a default, either by buyer or seller. Under this contract, if a buyer defaults, the seller may elect to receive the deposit or seek specific performance, which means the seller can go to court to have a court enforce the buyer to perform under the contract. Similarly, if a seller defaults, a buyer can either terminate the contract or force the seller to perform through specific performance. A buyer under this contract does not have the right to get damages under this contract. From a seller's perspective, this is why it's so important for the deposit to be meaningful and material, because practically speaking, the seller's remedy is to receive the deposit as their damages. It's very hard for a seller to force a buyer to perform, especially if there's a lender involved. But once there's a default, either party has to notify the other in writing, and paragraph 16 sets forth the dispute resolutions. That buyer and seller will have 10 days after the date conflicting demands are made for the deposit to resolve it. If they can't resolve it, then either party can go to court or arbitration. The biggest thing about these contracts, and here's the teeth, is that the prevailing party under any litigation or enforcement gets attorney fees and court costs reimbursed from the non-prevailing party. So going to court is extremely expensive. It's more expensive when the other side or one side has to pay the other side's attorney's fees. And this is what we remind buyers and sellers if they're thinking about going under a default and what their ramifications are. So always, if there is a default, realtors, please refer your clients to a lawyer in order to tell them what their rights and their obligations and what the potential ramifications will be.